Good morning and good afternoon to everyone. Welcome to this quarterfinal of the Rio Pre Moot for the Viz Moot. Well done for getting this far. Before we begin, I'm just going to introduce myself and I'm going to invite my co-arbitrators to give a short introduction. My name's Federico Singaraggio. I am a barrister and an arbitrator practicing from my chambers in London, Hardwick, and my chambers in Sydney in Australia, 13 Wentworth, Selborne. I'll pass over to Cesar.
Hello, my name is Cesar Pereira. I'm a lawyer and an arbitrator based in São Paulo in Brazil. And welcome to the quarterfinals.
And Joaquim.
Good morning, good afternoon. I'm Joaquim de Paiva Muniz. I'm a lawyer and arbitrator and partner of Trinity Ross and Watanabe, associated with Baker McKenzie. Also one of the organizers of the 9 Rio Pre Moot. Congratulations for you to have reached the final rounds.
Thank you both. Before we begin, I understand that it's been agreed, therefore, that as far as procedure goes, the respondent will go first, followed by the claimant, and that when merits kicks off, then it'll be the claimant followed by the respondent, and that it's also been agreed that the time allocation will be 14 minutes for submissions, followed by a 1-minute rebuttal at the end of the procedure or merit session. Is that correct?
Yes, claimant agrees.
Thank you. Okay. Is there anything else that anyone would like to say before we begin? All right, I'll take silence as a no then. I make the time now 12:02 p.m. London time. So procedural respondents, counsel, you may begin whenever you're ready.
Yes, thank you, Mr. Arbitrator. Good afternoon from Jordan, members of the tribunal. My name is Jessica Masriki, and along with my co-counsel, Sima Swedat, we will be representing both respondents, Canvier Ltd and Vectorview Ltd. I'll be addressing the procedural issues of the case, and my co-counsel will be addressing the substantive issues of the case. Respected tribunal, claimant has initiated these proceedings due to the alleged uncertainty caused by the baseless allegations of Ross Pharmaceuticals. Yet claimant objects to this joinder despite the fact that the joinder of Ross Pharmaceuticals is the only way we can eliminate the uncertainty and put an end to Ross Pharmaceuticals' baseless allegations once and for all. Honorable members of the tribunal, my argument consists of 2 submissions. First, by virtue of Article 4 of the Swiss rules, the tribunal should accept the joinder of Ross Pharmaceuticals. And second, hearings to be held in May of 2021 must be held in person. Turning to my first submission, it consists of 3 parts. First, the claimant and Ross Pharmaceuticals have implicitly agreed to the joinder of Ross Pharmaceuticals by acceptance of the Swiss rules. Second, the tribunal should accept the joinder as it assists in determining the scope of the licensing agreement. And third, joinder will not endanger the enforceability of the arbitral award. Turning to the first part of the submission, the acceptance of the Swiss rules in the PCLA indicates implied consent to the joinder of Ross Pharmaceuticals. As per Professor Park, consent is the cornerstone of arbitration, even if implied from circumstances. And if I may lead the tribunal to page 16 of the record. Clause 14.1, which is the desperate resolution clause. In the first paragraph, the parties explicitly agreed to resolve their disputes in accordance with the Swiss rules, and this is the PCLA concluded between claimant and respondent number 1. And now, if I may direct the tribunal's attention to page 33 of the record.
What's the document at page 33, counsel?
It's the Ross agreement concluded between respondent number 2 and Ross Pharmaceuticals, and in clause 14. Yes, Mr. Arbitrator. And in clause 14.1, the parties also agreed to resolve their disputes in accordance with the Swiss rules. And therefore, all the parties are deemed to have implicitly consented to any provisions the Swiss rules provide regarding the issue of joinder. Whereas Article 4.2 of the Swiss rules has the flexibility that enables joinder without the explicit consent of the parties based on the mere fact that the Swiss rules have been chosen as the applicable institutional rules.
Counsel,
And according, yes.
I have a question for you. What you're saying is that the election of the Swiss rules amounts to implied consent by Ross Pharmaceuticals to be joined under any circumstances. Is that correct?
Yes, Mr. Arbitrator.
But how can any jurisdiction of the tribunal extend to Ross Pharmaceuticals until there are any ongoing proceedings? Until it has triggered its arbitration clause, in other words?
If I understood, yes, Mr. Arbitrator. If I understood your question correctly, then by Ross Pharmaceuticals' acceptance of the Swiss rules, they have consented to the possibility of joinder and any other procedural issues under the Swiss rules.
But is that even if there is implied consent, as you state, wouldn't that implied consent only become triggered once it had engaged in arbitral proceedings, once there were arbitration proceedings pending? It can't be brought in to any dispute under the Swiss rules purely because it's got an arbitration agreement by Swiss rules. Is that what you're saying?
No, Mr. Arbitrator. The parties implied explicit acceptance of the Swiss rules and applies the consent to joinder is not the only reason the tribunal should accept the joinder of Ross Pharmaceuticals. And that leads me to the second part of my submission, in which I will provide you with the circumstances that the tribunal are supposed to take into consideration when deciding on the issue of joinder. And that would be two. First, the link between the claim pending between the original parties and the claim against the third person to be joined. And regarding this point, the dispute between the Ross agreement and the PCLA are inseparable, as one influenced the other into submission to arbitration. And according to Professor Vosser, the tribunal must establish a balance of interest test to determine whether the interest of joining Ross Pharmaceuticals prevails over claimant's rejection of it. And it will be found that respondent's interest is to put an end to Ross Pharmaceuticals' baseless allegations over the Gore-Atkan viral vectors to be used in respiratory diseases.
Consequently, okay, counsel, yes. I think my question at the moment is, what are you saying is a dispute? Because if Ross Pharmaceuticals or the respondent hasn't issued proceedings, where is the dispute between them which should be joined to this dispute? That's my question.
Mr. Arbitrator, although Ross Pharmaceuticals has not raised proceedings against either parties, they do have the policy to vigorously pursue their IP rights, and they do allege a right over the Gore-Atkan viral vectors. And this is why the joinder of Ross Pharmaceuticals to these proceedings, for respondent to prove that they do not have a right over the Gore-Atkan viral vectors, is necessary.
All right.
That also. Yes. I just have a quick question from a procedural point of view. Isn't joining Ross in this case going to broaden the issues under discussion? And doesn't that frustrate the subject matter that we are required to address here based on what claimants submitted to the tribunal?
Yes, Mr. Arbitrator, I understand your concern. Yet claimant initiated these proceedings alleging that respondent number one has breached their contractual obligations in the substance of the case, and especially in the Gore-Atkan viral vector, to have third-party rights. And without a joinder of Ross Pharmaceuticals, we cannot prove that there are no third-party rights over the Gore-Atkan viral vectors, consequently proving that respondent has not breached their contractual obligations, and therefore eliminating claimant's claim and the efficiency issue, which claimant has been unable to proceed their research over the Gore-Atkan viral vectors due to these third-party rights.
Sorry, counsel, just
Counsel,
building
I have
on,
a question.
Yeah, please, Joaquin.
Sorry. I have a question. How is cost advanced under the Swiss rules? Because would joining Ross increase the amount that claimant will advance? And according to claimant's argument, whether or not Ross, if I understood it correctly, whether or not joining Ross is not important from claimant's perspective, not prejudging. So it would be substantially increase the cost for claimant for something that claimant does not think it's important.
Mr. Arbitrator, joinder does not increase the cost of the arbitral proceedings. It reduces the administrative and legal efforts and thereby reduce costs, increase speed, and make proceedings more efficient. If claimant wishes to further...
Counsel, but doesn't the issue of who owns the IP right or what's the extension of the IP right, doesn't this issue have an economic value? So if you include this additional issue, it would increase the value at scale take, and accordingly it would increase the cost of the arbitration, the fees and the for the court and the fees for the arbitrator, if I'm not mistaken.
Yes, Mr. Arbitrator, a joinder decreases these costs, considering that a proceeding with 3 parties would be significantly less than 2 separate proceedings, especially that if claimant wishes to further develop the vaccine and continue to work on the core outcome viral vectors, they will have to raise proceedings against Ross Pharmaceuticals to prove that they don't have a right and that claimant has a right over the core outcome viral vectors to be used in respiratory diseases.
Oh. Okay, counsel, but if you have 2 separate proceedings, and if it's 50-50, like each side pays half of it, you're going to pay half of the first procedure and you're going to pay half of the second procedure. If it's everything in one procedure, then you have each side would bear 50%. But then you have claimant paying more that you would have paid if there were no joinder. How to tackle the situation? Not, I know that's an advanced cost, but it's an expensive chamber.
Mr. Arbitrator, first of all, it is the tribunal's decision who will bear the cost of joinder if there are any extra costs. And as I established earlier, 2 separate proceedings for a claimant would be significantly higher in cost than a proceeding of 3 parties resolving all of the disputes and all of the issues at hand.
Counsel, I just have, I'm conscious of your time, but I just have one last question on this point. You're saying that I think one of your submissions, unless I'm mistaken, is that you were not able to argue or defend the proceedings of the claimant without Ross Pharmaceuticals. Is that correct?
Yes, Mr. Arbitrator.
I just don't understand that submission, given that the only issue is the interpretation of the contract, and that part of the contract is already in the public domain. So what is it that Ross Pharmaceuticals would bring to these proceedings that without that element, you wouldn't be able to defend these proceedings? Can you explain that?
Yes, Mr. Arbitrator. The joinder of Ross Pharmaceuticals is significantly important, considering that we cannot examine the Ross agreement and the intentions of the parties in the Ross agreement without their presence in these proceedings and the use of Article 8, as my co-counsel will establish further, proving that the scope of the license given to Ross Pharmaceuticals does not include respiratory diseases, consequently proving that respondent number 1 has not breached their contractual obligations and Ross Pharmaceuticals has no right over the viral vectors.
Right, so it's the entire agreement that you want to bring in. Is that what you're saying?
Yes, Mr. Arbitrator.
I see. I understand.
If the tribunal has no further questions, I will move to my second submission.
Please.
This submission consists of 2 parts. First, the parties in the Desperate Resolution Clause agreed to hold the hearings in person, granting minimal discretion for the tribunal. Second, the circumstances of the case justify respondents' objection to hold a remote hearing. Turning to the first part, it is necessary to deduce the intent of the parties from within the arbitration agreement, and it will be found that the parties have practiced the principle of party autonomy and agreed to hold the hearings in person, either in Vindabona or in the city where respondent has its place of business.
Sorry, counsel, time is coming short. You're arguing that the virtual hearing should not go ahead virtually, that the arbitration should be in person. Is that right?
Yes, Mr. Arbitrator.
Can you just explain to me in one question, which is, what is the prejudice to you if it does go ahead, in contrast with the alternative, which is just to adjourn it indefinitely?
Yes, Mr. Arbitrator, as I can see, my time is almost elapsed. If you'd grant me an extra minute to answer your question and conclude.
I don't have any objection, co-arbitrators.
That's okay.
One more minute, counsel.
Mr. Arbitrator, if the hearings are to be held virtually, that would be a violation to respondents' right to be heard, right of equal treatment. Considering that the examination of witnesses and expert witnesses will be less effective, and virtual hearings will undermine the confidentiality of the arbitral process due to cybersecurity issues.
Counsel, can I just ask you, you're arguing this in the context of equal treatment, but both parties will be affected equally by this. So again, why will you be disadvantaged above and beyond the other side?
Yes, Mr. Arbitrator, if I may lead you to page 58 of the record, which is the PO2, paragraph number 38, the technical equipment on respondent's side is not as efficient as claimants. And Mr. Arbitrator, if I have misinterpreted myself, I argued the confidentiality and the credibility of the witness examinations under respondent's right to be heard. Yet,
sorry, counsel. Paragraph 38 uses the word may be less effective as opposed to is less effective. Is there any evidence that it actually is rather than it might be?
Mr. Arbitrator,
and if I may add, just in the interest of time, why would that be relevant? Because the difference in equipment, the difference in means, in resources, is not necessarily a problem of equal treatment between the parties. Parties are different, and they rely on their resources. And why would that be a problem here specifically? Since we are all dealing with technology, and we have been dealing with technology much before the pandemic. And so why is it a problem of equal treatment or due process?
Yes, Mr. Arbitrator, as I can see, the extension of time has finished. So if you'd grant me an extra minute to answer your question.
You can answer this question, counsel.
Yes, Mr. Arbitrator. It cannot be excluded with 100% certainty, and it is mentioned in the record that it cannot be excluded with 100% certainty that no third parties may interfere and obtain access to these hearings. It is the respondent's main concern that the confidential information to be exposed in these proceedings to be protected and the confidentiality not breached, especially that cybersecurity issues mainly arise when the parties and the witnesses are using their home network to attend virtual hearings. This cybersecurity threat will not only affect the confidential information, but also the personal information on the devices of the individuals that are to take part in these virtual proceedings.
Thank you, counsel. Okay, moving on now then to the claimants. Ms. Lees, I understand that you're speaking on behalf. I make the time here in London 12:19, so you're 14 minutes start now.
Thank you. Honorable Tribunal, Counsel for Respondents, and all those present, my name is Jana Lisi, and along with my co-counsel, Rodrigo Bellotti, represent claimant in the present arbitration. To clarify claimant's position, I will now address the procedural issues of the dispute, and my co-counsel will address the substantive ones. In order to answer respondents' arguments, my submissions to this tribunal will be divided into the following. First, Ross Pharmaceuticals cannot and should not be joined to the arbitral proceedings. And second, the examination of witnesses and experts should be conducted remotely. Moving on to the first issue, despite respondents' allegations, the tribunal lacks the power and the jurisdiction necessary to order the joinder of Ross Pharmaceuticals. It is claimant's contention that these two matters are closely intertwined, and in that, By not having jurisdiction, the tribunal has also no power over Ross Pharmaceuticals. Honorable Tribunal, we have to remember that what we are dealing with here today is the possibility of joining a third person non-signatory to the PCLA that has explicitly refused to be joined.
Counsel,
Respondents have yes.
Before you continue, can I just ask a question? Why do you oppose the joining of Ross Pharmaceuticals, seeing that the only issue that you raise in your claim is solely to do with the extent of the rights granted to Ross Pharmaceuticals?
Claimant opposes to the joining of Ross Pharmaceuticals because notwithstanding what respondents have raised, the claims raised by claimant and respondents are not linked. Claimant's allegation does not have anything to do with the scope of the license in the grant agreement, but in fact with the existence of a threat of a claim by Ross in regards to the license granted by respondent number 1 to claimant in the PCLA.
So do you accept that? Do you accept that Ross Pharmaceuticals hasn't actually been granted any rights which overlap with your rights?
That is a discussion that will be more broadly approached by my co-counsel. However, it is the jurisdiction in regards to claims and third-party rights that a party could raise a claim or a threat of a claim without a right, or have a right without raising a claim. And therefore, that is not an issue in regards to that a claimant should withstand. Because in fact, it is the burden of proof of respondents to prove that Ross Pharmaceuticals has a right in regards to the licenses. This is not, according to the CTD media case, it is respondents' burden of proof to prove the existence of a right. Claimant's burden of proof is only to prove the existence of a threat of a claim that would be enough to render the goods non-conforming.
So your case is really that there is a claim or an assertion of a claim. Your general position as far as whether or not there is in fact an overlap, whether or not Ross Pharmaceuticals were granted an exclusive license on matters which you were then granted a non-exclusive license, you accept that that's not an issue, do you?
It is not an issue because when claimant signed a PCLA with respondent number 1, it had not even had access to the Ross agreement before, so it would be impossible for a claimant to be in any way considered responsible for knowing anything that was written in the Ross agreement. And this is again a burden of proof of respondents.
All right, I understand.
Counsel, I just have 2 very quick questions, if I may. One is, you said Ross is not a party to this contract, but it seems that Ross is a party to a contract that's connected with this one. And wouldn't that be enough for us to consider as a relevant circumstance to bring Ross to this matter? And the other question is, even if your contention in the merits is that there is merely a claim from Ross Pharmaceutical, wouldn't it make sense in terms of efficiency and to settle this matter finally to bring Ross to this case and let them confirm that they do have a claim or not, and then we will consider. We don't have to have a full blown case regarding Ross. We can take that in steps and maybe just examine the issue of whether they do have a claim or not. Isn't that better for the whole procedure?
I'll add to Caesar's question. Counsel, you mentioned 3 times respondent has the burden of proof. And to my knowledge, the main defense of respondent is that the claim is frivolous. So wouldn't joining Ross be important for respondent to show that the claim is frivolous? Don't you think that's important for respondent's right of defense?
To address all the questions, I will first address the alleged connection between the contracts. Bottom line is the Ross agreement was signed in 2014. The PCLA was signed in 2019. In fact, none of the parties are connected because respondent number 2 and Ross Pharmaceuticals are the parties of the Ross agreement, and respondent number 1 and claimant are the parties of the PCLA. There is in fact absolutely no connection between the contracts. And
but
again,
counsel, sorry,
the claims.
You have created a connection by bringing in both respondents into this arbitration, despite the fact that they're not a party to your agreement. Isn't that right?
Yes, respondent number 2 is not a party of this agreement. However, there is a specific difference between joining Ross and joining respondent number 2. Respondent number 2 is a subsidiary of the same group of company of respondent number 2, Roctis AG. However, Ross Pharmaceuticals is in fact a competitor in regards in comparison to claimant. The relationship is completely different, and by reason that it's completely different. And in fact, claimant understand that respondent number 2 accepted the joinder, it consented to the joinder due to this relationship of group of contracts that would entail an implicit consent. In fact, could entail an implicit consent to being joined. In regards to the second question, why joining Ross will not help settle this matter? Those are absolutely two different matters. The existence of a threat of a claim does not need the participation of Ross Pharmaceuticals to be proven, because Ross Pharmaceuticals would only be because the participation of Ross Pharmaceuticals would only cause more costs in these proceedings, and as it has been discussed in my opposing counsel pleading, that in fact it seems that respondents are trying to join a third person by using the requirements of Article 4.1 of the Swiss rules, not Article 4.2. Article 4.1 regards a consolidation, and in fact, since the respondents' contention is that they are trying to join Ross because it would be better than avoiding two proceedings, the present one and a hypothetical one that claimant maybe would create, and how would respondent know what claimant will do in the future? And it seems that this futuristic adventure that respondents like to do is in regards also to the implicit consent that Ross Pharmaceuticals would have given when it's agreed to subject itself to arbitration under the Swiss rules, and the tribunal would have jurisdiction over Ross because of that. But in fact, that is not true, because the fact that the Ross Pharmaceuticals signed an agreement under the Swiss rules is simply a fact that Ross Pharmaceuticals and respondent number 2 decided that they would be arbitrated by the Swiss chambers. And in fact, that is a practice of respondent number 2 to arbitrate under the Swiss chambers. And if you were to understand that, that would mean that all of respondent number 2 contractual parties and contractual agreements would then also be liable to be joined to this arbitration, simply because they all were subjected to the
Counsel,
chambers.
Can I ask you a question on that? Your opponent made a submission that without the joining of Ross Pharmaceuticals, the entire agreement, the entire CLA would not be able to be produced, therefore preventing them from properly proving that the claim from Ross is frivolous. So if we do not permit the joinder, are we not preventing the respondents from defending this claim? Are we not giving them unequal treatment?
Mr. Arbitrator, if I have understood your question correctly, it's about the production of the PCLA. However, if the
production of the CLA.
Oh, the CLA, respondents could, the CLA between respondent number 1 and respondent number 2 could then be produced by respondents, since Ross Pharmaceuticals is not a party of this contract. Ross Pharmaceuticals
I think the CLA,
this contract.
It's the agreement between Ross Pharmaceuticals and respondent number 2, I think, is what they want to.
Oh, the Ross agreement. In fact, we have the Ross agreement in the records. If the tribunal could please follow me to page 32 of the records. We have the entire agreement here. So the production of the agreement is simply in the records. That would not constitute a problem.
Okay.
In counsel, sorry, one last question from me here. Do you think the tribunal would have the power, if we decided to do something in between, to order the hearing of testimony from Ross's CEO to confirm the existence of a claim? Do you think the tribunal would have the power to do that as a compromise measure?
The tribunal would not have the power to order the testimony of this Ross Pharmaceuticals CEO, since the tribunal does not have jurisdiction over Ross Pharmaceuticals. However, if the tribunal could please follow me to page 35 of the records, Ms. Julia Bode, this is an email by Julia Bode, and she is the CEO of Ross Pharmaceuticals, and we have this information here already from correspondence between respondents and Ross Pharmaceuticals, and that would be enough to prove that there has been, not only that, but all the proofs in the records, all the documents in the records are enough to prove the existence of a threat of a claim. And since the tribunal does not have jurisdiction over Ross, it does not have the power to order the joinder or a consolidation in regards to Ross. Well, moving on to the second issue, respondents raised three main concerns: their right to be heard, their right to equality, and cybersecurity. In regards to their right to be heard, it is very simple to understand that all the possible technical difficulties in remote hearing can be solved. For example, we could access nonverbal cues by utilizing multiple cameras around the witnesses, and a 360-degree camera would avoid any sort of coaching of witnesses. And if respondents do not have this technical apparatuses, we could simply ask the witness to go around the room with the camera, showing everyone that there is no one there. And
Counsel, would your clients be prepared to pay for any additional costs so that the hearing could proceed virtually? If that was the cost of proceeding virtually, would your client be prepared to pay for the costs, any additional costs?
My client would be prepared. However, if the tribunal could please follow me to page 58 of the records, on paragraph 38 of the procedural order number 2, this cost in regards to respondents would not be needed, because even though respondents argue that respondents' technical apparatuses seems to be less affected, may be less affected, as Mr. Chair has raised. In fact, if we go to the third line of the response, from the technology side, all participants potentially involved in an oral hearing have sufficient bandwidth and equipment to guarantee that a hearing can be held. Therefore, not only the cost will not be needed, but also the right to equality consent is not at all a problem. And if the tribunal could please...
As I understood your opponent's submissions, it was framed in the sense that their main concern was cybersecurity and their ability to protect their data, and specifically their personal data. Can you just address us on that?
Yes, of course. I see my time has elapsed, and if the tribunal could give me one more minute to address this issue and conclude.
Unless there's any objection, actually, your opponent had 3 minutes, so I'm prepared to give you your 3 minutes.
Oh, thank you. Well, in regards to cybersecurity concerns, adopting cyber protocols would solve any sort of issues in relation to this confidentiality concern. We could adopt the cybersecurity guidelines by the IBA, or the protocol on security in international arbitration by the International Council of Commercial Arbitration, or claimant is open to respondent suggestions in any protocol to be adopted.
Do you have a suggestion of the most adequate protocol to be used in these circumstances, counsel?
Yes, the ICC cyber security protocol seems to be extremely adequate, and the IBH protocol as well. However, again, we are open to suggestions.
Why do you say the ICC protocol is the most adequate in these circumstances?
Because the International Chamber of Commerce has a record of holding remote hearings, and there has been no record of them having any problems in regard with confidentiality leaking.
Is there anything specific in that protocol that you want to address this on?
Well, nothing is specific.
Thank you.
And in comparison to in-person hearing, the cybersecurity issue would also exist in an in-person hearing, because transferring electronic documents via insecure sharing portals, or even participants that do not use appropriate firewalls and anti-spyware softwares, would endanger the confidentiality of these proceedings, and therefore cybersecurity can be solved, is an issue that can be solved in remote hearings, but also would exist in an in-person hearing. And to conclude my argument, I would like to quote the CAPEC versus Ford Motor Company of Australia Limited case that was decided in July 2020, in which the Federal Court of Australia held that technological limitations do not constitute a substantive obstacle to holding a virtual hearing. In fact, the court's primary consideration was the health risk posed to protectionist witnesses and the court staff. And that is actually a serious concern in this case, since some of the participants do not feel comfortable traveling. And if the situation does not change until May or until the 4-month delay that is expected, and all of us would be subjected to COVID-19 risks. And with that, I close my submissions and thank the arbitral tribunal.
Counsel for the respondent, your rebuttal.
Yes, Mr. Arbitrator. My opposing counsel just stated that we are before a consolidation under Article 4.1 of the Swiss rules, yet the requirements of consolidations are not present in these proceedings, as consolidation is the joining of two lawsuits, and Roth has not yet raised arbitral proceedings against either one of the parties. We are before joinder under Article 4.2 of the Swiss rules, which is the joining of third parties. Thank you.
Thank you, counsel. Counsel for the claimant, your rebuttal, please.
It appears that counsel for respondents have not understood claimant submissions. Claimant submission was in fact that what respondents is trying to do is to mix the consolidation requirements with the joinder requirements that, in fact, the joinder requirements under Article 4.1 of the Swiss rules do not require the parties to be the same. However, the joinder would create a problem to join a non-signatory, and that is the situation with Ross Pharmaceuticals that respondents are trying to ignore. Thank you.
Thank you. Thank you, counsel. Well, that ends the procedural element of this hearing. We'll then move on to the merits. I understand that the claimant shall go first. I make the time now 12:37 p.m. in London. So, counsel, for the claimant, Mr. Bellotti, you may proceed whenever you're ready.
Thank you, Mr. Presiding Arbitrator. Good morning to the members of this tribunal, to my opposing counsel. My name is Rodrigo Bellotti, and I shall be addressing these substantive arguments on behalf of claimant in today's proceedings. We are here today, members of the tribunal, in light of respondents' refusal to recognize the imminent danger of their contractual relationships these that have spawned a third-party incumbrance over our clients' use of the viral vectors pursuant to the PCLA. Now, in light of such, claimant would like to dissect the factual evidence of this case and guide the tribunal to establish two submissions. First, that the CISG is applicable to the PCLA, and second, that respondent number 1 failed to honor its obligations as pursuant to Article 42 of the CISG. Now, coming to my first submission, members of the tribunal, it shall be conveyed that it is the CISG that applies to the PCLA. But before anything else, claimant would like to take a step back.
Counsel, can I ask you a question? Do you say the CISG applies to the Ross agreement?
The PCLA.
No, I'm asking you a question about the Ross agreement. Would you say that the CISG applies to the Ross agreement? The CLA.
Yeah, the Ross agreement also under the laws of Danubia, by being a contract on similar terms and structure as the PCLA, would also include, in the light of the laws of Danubia, the CISG as well.
What are the goods being transferred in the Ross agreement?
The same ones under the ramifications of the PCLA, viral vectors, base materials for the production of vaccines.
All right, so you say that the goods are the viral vectors themselves?
Absolutely, yes, precisely, Mr. Arbitrator.
All right, please proceed.
But before anything else, claimant would like to take a step back and start by acknowledging that the PCLA, it is a complex agreement. It entails multiple obligations. So with this first submission, what claimant would like to do is to explore the PCLA and to sustain that within its obligations, 2 points must be observed. The first, that within its obligations, all of the elements of sales under the CISG are observable. And second, that these sales obligations, they are the preponderant variable within the PCLA. So starting with my first point.
Counsel, what do you say is the definition of preponderant in these circumstances?
The definition of preponderance would be the substantial contractual variable of a contract. And to establish the substantial variable, we must base ourselves in a criteria, and as shall be guided by my second point. This criteria is party intention.
All right, please proceed.
Thank you, Mr.
I just have a quick question before you go on. Wouldn't it be more adequate for us to see the PCLA, the contract here, not as a mixed contract, but as two separate contracts, one for the current stage of the relationship in a promise of a possible purchase in the future as a separate one? Why would we consider this a mixed contract in which we would have to assess what the preponderant obligation is, instead of a combination of a current contract and a possible future purchase?
What the PCLA offers, Mr. Arbitrator, are different phases of a same contractual relationship. There are research phases, there are production phases, and commercialization phases. But these phases allude to the very same project, that is the production of a vaccine. And with this in mind, it would not make absolute sense to divide the contract, given that there are complementary relationships with sales, licenses, all for a common goal, which is to research, develop, produce, and commercialize a vaccine. They all pursue to the same factual and contractual matrix. So, with that in mind, to define a sale and to see if it is observable, the definition of a sale under the CISG, in accordance to Professor Schlettriam and Schwenzer, the contract of sales is defined as a reciprocal exchange of a good against a price. So there are three ultimate elements that define a sale: a good, a price, and an exchange. And all of these elements, members of the tribunal, they are observable in the present case. There are good.
Sorry, you stated a moment ago that the definition of preponderant was a substantial part of the contract. So the mere fact that these elements of sale exist doesn't make it the preponderant element, does it?
It does not. It makes us see from a purely objective standpoint that sales exist that may be countered by opposing counsel in the form of respondents. So the objective of the first point is to see that there are proper sales within this contract, and subsequently, the second point, that these sales are preponderant. So perhaps.
But how is the substantial part not the intellectual property in the use of the viral vectors, as opposed to the vessel upon which they're carried in?
I hear your concern, Mr. Arbitrator, sir. So perhaps I should move on to my second point and discuss preponderance.
Please.
As if all the members of the tribunal agree.
I don't think it's a disputed issue that there are goods being transferred under this contract. I think the only dispute between the parties is what is the meaning of preponderance and how should it be applied.
I agree. I agree, Mr. Arbitrator. It was just to address a couple of concerns that opposing counsel might raise. But in terms of preponderance, to establish which variable is preponderance, we must base ourselves in a criteria. And this criteria, members of the tribunal, is established in the CISG Advisory Council Opinion number 4 from 2002, as well as the cylinder case, the cloud case number 346 from the District Court of Mainz in 1999 as party intention. The party's will, the party's desire in making the substantial elements of the contract. And in the present case, it is claimant's submission that the preponderant element of this contract is to establish long-term sales obligations for the delivery of base materials for the production of vaccines. Now, opposing counsel might say that economics is a true criteria for us to apply, but the very same CISG Advisory Council Opinion number 4 clearly states that economics is only a starting point. It must never replace the true main objective at stake, which is party intention. And if the tribunal could follow me on this regard to page 10 of the record, it is a Life Science Today article from the 29th of November in 2018. And please tell me when you're there.
Yeah, I'm here.
I could direct your attention to paragraph 7 of this article, which is on the right-hand column. It starts with "in addition."
Yeah.
It clearly states that the idea and goal of contracts such as the PCLA is not only to deliver a first batch of viral vectors, but to continuously deliver at least the base materials for vaccines production. And this leads us to see members.
Sorry, Council, just help me with something. At the outset, you made a submission that the goods here were the viral vectors, and that's what we're dealing with, okay? And that's why the CISG applies. But now you're talking about other elements, which are not the viral vectors, to persuade us that this is a contract for goods. So which is it? Is it the viral vectors, or is it the other stuff that you're relying on?
Let's take a step back, Mr. Arbitrator. The goods at stake are the base materials to produce vaccines. These base materials include the viral vectors, the cell cultures, the cell mediums, the HEK294 cells, any material that may serve as a base for a vaccine, which includes the viral vectors. And on the same line, in paragraph 6, which is the paragraph on top of this paragraph, Mrs. Alexandra Fleming, the CEO of respondent number 1 herself, admits that the ultimate goal is to regularly and continually produce and sell these base materials to fulfill the demands of future vaccines producers, confirming the goal, confirming intention to satisfy market demands and sales demands of vaccines producers, including our clients. This reflects the ultimate intention of this contract, the will of the parties to sell goods, to sell base materials, to produce vaccines. And by having a preponderant intent to sell these vaccines under Article 3, Paragraph 2 of the CISG, sales prevail. This is a prevailing sales contract, and the CISG applies to the PCLA.
Council, just one question. But
yes,
without the license to use these specific viral vectors, there is no possibility of any vaccine at all. All the other elements, as my co-arbitrator has pointed out, they're conditional on the research, but the license of the viral vectors, they are fundamental to the research, aren't they? So why shouldn't they be interpreted by us as the preponderant element?
All of the elements of the PCLA, Mr. Arbitrator, they may be seen as fundamental for one purpose or another. From a purely intellectual property.
Sorry, Council. The subsequent goods sales elements are conditional upon the successful research into a vaccine. So they may or may not come to fruition down the line. But the viral vector licensing, that is fundamental for engaging in any research whatsoever. Without the license, you couldn't do any research, could you?
Not only without the license, but without the base materials themselves, which are the core of this contract, Mr. Arbitrator. Without these base materials, without the satisfaction of the market demands of vaccines producers in terms of materials, the contract as a whole would fall on its pieces. So there are fundamental aspects in both ways, but in terms of intention, in terms of intentional predominance, sales prevail, base materials prevail. And if there are no further questions, perhaps I could conclude this.
If you could just clarify something to me here. Under the contract, is your client prevented from buying these materials from any third party after the research successfity proves that the vaccine can be done? Is the contract based on some exclusivity provision about where to purchase these base materials later?
Exclusivity is not the exact term, Mr. Arbitrator, but in clause 16.1 of the PCLA, it states that if the vaccine is adequately and properly developed, then claimant must buy the remainder of the HEK294 cells and base materials from respondent number 1. So there is this conditional and subsequent relationship. So perhaps I should move on to my second submission, which regards that in case the CISG is ruled upon as applicable, which it is, respondent number 1 failed to honor its obligations as pursuant to Article 42 of the CISG. Now, Article 42 of the CISG, it entails the seller's liability when faced with a third-party claim or right of which, at the time of the conclusion of the contract, it knew or could not have been unaware of. And in light of such, claimant raises 2 points. First, even though there is not a formal claim or formal legal assertion at play, the threat of one is sufficient to trigger Article 42 of the CISG. And second, that such threat was very well known about by respondent number 1. Now, to start us off, there is a strong doctrinal current, including the likes of Professors Kroll, Tabo, Janal, Akili, Staudinger, all stating that the threats of a legal proceeding, and if a legal proceeding is fairly likely to occur, then Article 42 of the CISG is triggered. Now, what respondents submit is that a threat of a legal proceeding is highly likely to occur. And this is in light of the fact that not only does Ross have an active reputation for enforcing its rights.
Counsel, can I just ask, did the parties not derogate from Article 42 in terms of Clause 11 of the PCLA?
In terms of Clause 11, it establishes a complementary relationship with Article 42 of the CISG. They are complementary at best, so meaning that a violation of one is also a violation of the other. Now, in light of Ross's active reputation, and I kindly request an additional minute and a half just to conclude my submission.
Sorry, can you just address me on that question specifically in light of 11.1.4?
Yes.
Is that not restricting the scope of Article 42 to only matters that are within its knowledge or occurring at the time?
It does. But what claimant will submit is that such threat of a risk was foreseen at the time of the conclusion of the contract. So there is still a complementary relationship, a violation of...
My difficulty is this, counsel.
Yes.
If Article 42 is to prevail over Section 11.1.4 of the PCLA, then what is the purpose of Section 11.1.4? Because what you're asking me to do is to prefer an implied term over an express term.
It is not implied, Mr. Arbitrator, in the sense that Clause 11.1.4 talks about claims in a general form. It talks about settlements. It talks about legal disagreements in its general variant.
Exactly. So is it not restricting Article 42, and are the parties not specifically choosing to engage under those parameters in preference to Article 42 by including a specific clause that was negotiated and agreed?
I understand your concern, Mr. Arbitrator, but the ramifications of Clause 11.1.4, they are still triggered by the same submission in regards to Article 42.
All right. Thank you, counsel. Your time is up now.
Could I just request an additional minute and a half to conclude?
You can have a minute, subject to any objections from my co-arbitrators.
Absolutely.
You can have an additional minute, counsel.
Thank you. So not only does Ross has an active reputation, as it has also already started preclinical trials in terms of COVID-19 and a vaccine. So all that claimant is asking is for this tribunal to recognize that if this situation goes unchecked, and we have both our client and Ross continuing to further their research, continuing to work on vaccines, a legal proceeding, legal overlap is not a matter of belief, it's not a matter of probability. It is simply a matter of time and a risk that was foreseen by respondent number 1 in light of the fact that it knew very well in its own terms that Ross was bargaining for a free license ever since the summer of 2018. So there was a risk, there is a risk, and a risk that was foreseen, and I conclude. Thank you very much.
Thank you, counsel. Counsel for the respondents. I make the time now 12:54 in London, so you have 14 minutes from now, whenever you're ready.
Thank you, Mr. Arbitrator. I see that I have a delay in my internet connection, so please, if any time it disconnects, please let me know.
Thank you.
Thank you, Mr. Arbitrator. Good afternoon, members of the tribunal. As my co-counsel introduced me,
you've just dropped out for me.
Oh. Can you now hear me?
Yes.
Yeah.
Okay, I would repeat. Okay, I would start again. Good afternoon, members of the tribunal. As my co-counsel introduced me, my name is Seema Swedat, and I'll be representing respondent number 1 and respondent number 2 on the merits of the case. Respected tribunal has set in motion the present arbitration, centering on baseless allegations by Ross Pharmaceuticals. Yet Ross Pharmaceuticals has never approached claimant or even threatened to bring proceedings against it, leaving us to wonder whether the present arbitration is simply a tactic by claimant to prevent respondent from granting a new IP license to Ross and thereby eliminating one of the horses in the race to the COVID-19.
Sorry,
Yes.
we're talking about a dispute in terms of a vaccine for the COVID pandemic. This is a wholly unprecedented situation, which is analogous only with wartime situations. So, is your submission that this arbitration is frivolous in those circumstances?
Mr. Arbitrator, we would not submit that the arbitration is frivolous. However, the claims that are raised in the case at hand by Ross Pharmaceuticals are frivolous, as there are no third-party claims or rights over the viral vectors. And respected tribunal, with that, I'll be making 2 main submissions, and my arguments would proceed in the same order as my opposing counsel, consisting of 2 main submissions. The first is that the CISG is not applicable to the purchase, collaboration, and license agreement concluded between claimant and respondent. Secondly, respondent number 1 has not breached its obligations under Article 42 of the CISG and delivered Borat-CAM viral vectors free from third-party rights and claims. Respected tribunal, before submitting my first submission, I would like to indicate that contrary to what my opposing counsel has asserted, the Ross agreement that was concluded between respondent number 1 and Ross Pharmaceuticals is actually mainly a licensing agreement and did not involve any sales obligations. And respected tribunal, regarding my first submission, I'll be making 1 main point, is that by virtue of Article 3.2 of the CISG, the preponderant part of the PCLA is the licensing obligations, contrary to what my opposing counsel has set forth.
Counsel, I have a question. You state that the original CLA is predominantly a licensing agreement, but even if that is true, in this case, your agreement is a PCLA, and as I understand it, it was your clients who introduced the purchase element. Would that not make it so? There is a distinction. So they're not comparing like with like, are you?
No, Mr. Arbitrator, this is why we are conceding to what my opposing counsel has asserted, that we are in front of a mixed contract that involves both services and the delivery of goods. And this is why we are arguing under Article 3.2 of the CISG that the preponderant part of the PCLA is the licensing obligation and not the sales obligation. And under the Advisory Council Opinion number 4, there are 2 tests in order to determine what the preponderant part of the contract is. We also concede that the economic value test is inappropriate in the case at hand. Hence, the tribunal is to take into account the essential criterion test. And under this test, the purpose of the contract and the intentions of the parties once contracting should be taken into consideration.
And what do you say that intention is?
Mr. Arbitrator, we submit that the intention is purely a licensing agreement, since if I first may please lead the tribunal to page 30 of the record.
Before you take us there, counsel, can you just
this is the witness statement of
Can you just respond to your opponent's main submission, as I understood his case, which is that without the goods, there could be no research for vaccination, that the preponderant part of this contract is the provision of the viral vectors and the HK cells, etc.
Mr. Arbitrator, we submit the complete opposite. We submit that without the transfer of know-how and the licensing obligations, it would be impossible to utilize the viral vectors to further develop them into vaccine. And this is also shown by the intentions of the parties once contracting the PCLA, where if I once again may please lead the tribunal to page 30 of the record, which is the witness statement of Mr. Peter Doherty, who at first used to work for respondent number 2 and is currently working for respondent number 1. And in paragraph 7, the last 3 lines, it reads, Respivak, which is claimant, had, however, serious objections against some of the provisions and was in particular of the view that the model would not sufficiently take into account the IP elements related. Respected tribunal, claimant itself stated that the template does not include sufficient IP elements that could reflect author in transaction. And this understanding is also apparent in the dispute resolution clause of the PCLA, where the parties agreed that all arbitrators should have good knowledge in the field of intellectual property and the development of vaccines. And if the parties truly considered that the licensing obligations in the PCLA were insignificant and were secondary, they would not have attributed that much importance to the command of the future arbitrator of IP law. And respected tribunal, my opposing counsel has also mentioned the cylinder case. However, in that case, there was an obligation to deliver cylinders, and there were also other accessory obligations that regarded the transfer and the installation and the uninstallation.
Sorry, counsel, can you just explain to me that first point on paragraph 7? Paragraph 7 says that at the time of negotiation, there were objections raised that this was a too goods heavy, if I can paraphrase, contract. Is that right?
Yes, Mr. Arbitrator.
And currently the claimant is arguing that this is a goods contract. So can you please explain to me how you say that is inconsistent?
Mr. Arbitrator, we are once again not denying that there are goods elements in the PCLA, which were found in section 9.2 and 16.1. However, if I may please refer the tribunal to page 55 of the record, which is the procedural order number 2, paragraph number 17. In the second line, it reads, for the production of the vaccine, however, there would be a transfer of know-how about the best procedures to amplify the viral vectors by using the HAK cells and the growth medium, which my opposing counsel has set forth.
Counsel, sorry, just can you respond to one point?
Tribunal, this clearly shows the importance of the transfer.
Your opponent said that
Mr.
he's not relying on the HK element of the contract. He says that it's a goods contract purely on the viral vectors basis.
Mr. Arbitrator, he also included that the HAK cells and the cell growth medium are part of what constitutes the goods and which is the sales obligation of the PCLA. However, what we are submitting that despite there being those sales elements, they pale in comparison to the main element, which is the licensing obligation. And to further
on what basis do they pale in comparison, counsel?
Mr. Arbitrator, the first is that the intentions of the parties once concluding in both the dispute resolution clause and in the witness statement. And secondly, the transfer of know-how, which is the licensing obligations, was repeatedly mentioned in the PCLA under provisions including confidentiality, licensors' representation, and results in the research acquired, which exhibits its invention once in section 9.2 of the PCLA.
Counsel, I just have a question here about from the seller's point of view. What is the purpose of having this contractual relationship? Having this first step now, this research step in the contract, isn't the purpose precisely to be able to sell later the base materials for the production of vaccines that the buyer would be able to produce? So from that point of view, isn't the end purpose of this contract precisely a sale of those goods, the base materials?
Mr. Arbitrator, we do agree with the first part that you have pointed out, that they are needed for the vaccine to be produced, and we are not denying their importance. However, when they are compared to the licensing obligation, they are not the preponderant part of the PCLA. And Mr. Arbitrator, as you have also previously mentioned, there is an exclusive.
I'm sorry, but just on that precise point, if the licensing part were preponderant, what's the logic of the parties having the second part of this contract? wouldn't it be enough for the parties to have simply stopped at the licensing at this first stage and say, here is the license, here are some base materials for you to develop a vaccine, and that's it. We don't have to worry about selling base materials later, because we are merely working under the licensing realm here. What is the logic of having the second part if the sale of goods is not the end purpose of this?
Mr. Arbitrator, once again, we do concede that we could never reach the last point, which is the production of the vaccine, without the delivery of the viral vectors. We are not denying their importance. However, Mr. Arbitrator, even if only the licensing part stayed at the beginning, we would also not be further led to anything related to the vaccine. However, with both of them together, we do have the enough transfer of know-how needed to utilize the vaccines and to produce them. However, this transfer of know-how pales in comparison to the delivery of the viral vectors, which is considered an accessory obligation in the PCLA and not the main part. If the tribunal does not have any further questions.
Counsel, no, I have a question. Just going back to Caesar's point, you said it's an ancillary obligation, but if you read the amounts involved for the sales are quite high, and the amount of sales and cultures is quite significant. How could that be ancillary? Why do you think it's ancillary if they have like a firm obligation to buy a very high amount of raw material for a very significant price? What's the criterion that you're using to say that's ancillary?
Mr. Arbitrator, we have used the essential criterion test. However, you were referring to the economic value test, where the sales obligation and the licensing obligation have to be compared from a price point of view. However, Mr. Arbitrator, in the PCLA, in section 9.2, which—
not only to that, not only to that, counsel, not only to the value, I'm not doing just the mathematics, also for the volume and the time. Like you sell, in addition to the price, you have a firm obligation to buy a significant amount of raw material. What's typical from a—
Yes, Mr. Arbitrator, there would be this obligation. However, this obligation is under 16.1 and 16.2, which is only in case of a commercialization, and that would lead us to uncertainty, which makes the economic value test inappropriate to the case at hand, since it needs accuracy and certainty. This is why we have referred the tribunal to the essential criterion test, which should be taken into account, where the parties' intentions have clearly been the licensing obligations, meaning it is the preponderant part of the PCLA, leading us back to the fact that the CISG is not to be applied. Respected tribunal. Yes.
No, but aren't you asserting that I can— Sorry.
Sorry, Counsel, you're out of time. Your opponent had an extra minute. I can give you an extra minute to address this on the second point.
Yes.
I would just suggest, Federico, that we give them 2 minutes, just to, because you still have to address the second point, and we asked many questions. So I would suggest 2 minutes.
Sure.
Thank you, Mr. Arbitrator. If there are no further questions, I would like to move on to my second submission, where I'll be establishing one main point, is that the mere risk of being confronted by third-party claims does not constitute a breach under Article 42 of the CISG, contrary to what my opposing counsel has set forth, where according to Professor Janal, and this was also found in the CB Media case, as long as the alleged holder of intellectual property rights does not raise a claim, the seller is not liable. The third party must assert its rights directly against the buyer, or the seller would have been overly burdened not only against the absence of third-party rights or claims, but also against the mere suspicion that these goods are subject to these third-party rights or claims. And respected tribunal, it's important to point out that Ross Pharmaceuticals has clearly stated in one of its emails that it is in the interest of both parties to solve the divergence in an amicable way outside the courts. This can be interpreted in a way that indicates that Ross Pharmaceuticals have not intended to go to court and will not, respect the tribunal. And further on, as my co-counsel has previously pointed out, nothing is stopping Ross Pharmaceuticals from raising their claim, as it has the policy to vigorously enforce its IP rights, as it is currently involved in 2 IP litigations and 1 arbitration against third parties allegedly infringing their rights. And respected tribunal, there is also the awareness under Article 42 of the CISG, which, as Mr. Arbitrator has previously pointed out, it clearly states in the PCLA that respondent was not aware of any third-party claims or rights, which is the correct time according to Professor Schleckner and Professor Schwenzer, which is at the time of the conclusion of the contract, which respected tribunal excludes respondent's liability. Therefore, on the whole, respondent submits that the CISG should not be applied to the PCLA concluded between claimant and respondent, and to hold that respondent number 1 has not breached its obligations under Article 42 of the CISG. Thank you.
Thank you, counsel. Rebuttal from counsel for the claimants.
Thank you, Mr. Presiding Arbitrator. Opposing counsel, in her own words, stated that an amicable solution is attempted to be placed. But the last time, members of the tribunal, we actually heard from Ross in the record is in page 35 in 2018, nearly 3 years ago. And claimant submits that times change, people change. We are living in a global pandemic. Although Ross has not dared to contact claimants about any potential violation, it has limited itself to continuing to work with viral vectors, to continuing to pursue a vaccine. So if this situation goes unchecked, there will eventually be legal overlap. And even if there are amicable propositions to this case, the very fact that 3 years have passed demonstrate that they are ineffective, that they are leading us nowhere. If solutions, if mediation were effective, if these offers were effective, the case would be settled, and not one of us would have to sit here today. Thank you.
Thank you, counsel. And counsel for the respondent, your rebuttal.
Thank you, Mr. Arbitrator. Respected tribunal, contrary to what my opposing counsel has asserted, even as I pointed out in my argument, since Ross Pharmaceuticals is known to enforce its IP rights, it did not approach which is its under Corona Science, which is their direct competitor. If they wanted to raise a claim, they would have under the PCLA and under Article 42 of the CISG. However, this has not been yet made, meaning there is no breach under Article 42 of the CISG. Thank you.
Thank you, counsel. Thank you to all counsel. That now concludes the merits element of this hearing. Thank you to all counsel involved. The 3 arbitrators now will retire to a breakout room where we will consider the results and come back to you as soon as possible. Please stay on, and we'll be back as soon as we can.
Lucas will put us in the breakout room.
I don't know. I clicked here on breakout rooms, but nothing really happened.
Let me try to help you. Joaquim, I just put you there. Says I just pressed the button for you. Let us hope that it works. Yeah, it worked. So we're going to wait for them here.
In name of FGV and our team, we'd like to congratulate you both in your submissions and in your pleading. It was a great experience.
Thank you so much. We also want to congratulate you both. It was a very nice experience, and we have the pleasure to plead against you both.
The biggest pleasure. It was an amazing experience. Thank you so much for experiences like these make all of us grow. And so,
definitely. Thank you.
We wish you all the best in Vienna, and hopefully we'll see each other again.
Yes, definitely. We wish you all the best too.
Hello, everyone. Welcome back. My co-arbitrators are now back. I think everyone who needs to be here is here. So first of all, congratulations to both teams. I know it's a bit of a cliche to say it's a difficult decision, but it truly was in this particular situation. We have to consider all the relevant elements, and it was very, very difficult to make a decision because of the incredibly high standard that both your teams are at, even with a week or so to go, 2 weeks before the actual Viz Moot. So first of all, congratulations on that, and congratulations on being this prepared at this stage. You also have an added obstacle this year, of course, which the last year's mootees had to deal with, which is remote hearings. Usually, most mootees enjoy being in Rio, enjoying the sunshine maybe after this this competition, but unfortunately you all have to go back to wherever you are, and you don't get to enjoy you know, a walk down Copacabana or Ipanema Beach after this session. But nonetheless, as I say, it's been tough, and especially congratulations to Seema, who dealt with the remote hearing challenges very well. But this is the reality that we're in today. And of course, this experience will be invaluable to all of you, I'm sure, because I cannot see that remote hearings will be abandoned after the pandemic period. So you have an additional skill that perhaps those who do not compete in these competitions will not have, and an advantage. So, as I say, congratulations to all four of you. You dealt with our questions very well, and you were very engaging and captivating to all of us. With great difficulty and a lot of consideration, I think if we were to select a winner, which we are forced to, then I think that would just be pipped to the post by FGV Rio. So congratulations to Diana and Rodrigo. Jessica and Seema, you both did incredibly well. And as I say, it was a very, very difficult task. Please do not be subdued by this result. You know, it was very, very close. And on another day and in other circumstances, you may well have been the winners today. So good luck to FGV Rio continuing. Good luck to Jordan in your other pre-moots, if you have any, or indeed at the Viz Moot itself. I know that I haven't got either of you in my moots at Viz, but I wish you the best of luck, and I hope to see you around in the circuits. If there are any additional words that my co-arbitrators would like to add, then I'll hand over to them.
Thank you, Federico. I have really nothing to add. I think your report of our discussions and everything was perfect and very comprehensive. I don't know if any of the teams is coming to the Viz East in Hong Kong. If you are, you're actually starting today. I have two hearings tonight, which will be tomorrow morning in Hong Kong. And so you may need, if you're going to Hong Kong, you may need to do the actual work there today, not in a couple of weeks. But you are indeed, as Federico said, very well prepared. This was a very enjoyable discussion and hearing, and well, congratulations to all of you, and thank you for this discussion.
I'd like to congratulate you. It was very, very hard decision. And I would like especially to thank Seema and Jessica. With all the internet connections, it didn't change anything, didn't affect. You did a wonderful job. We have to choose between one of the two teams, but I'm quite honored to have you at the pre-moot, and I invite you to be again next year. And for all of you, that the competition continues. And we have it was broadcast, this hearing was broadcasted through YouTube, and you circulate. It's good for you to see how to have this recording of how you acted, and that was a very good way to start the final rounds. Being the final already entitled to part of the prize, so you all, it's not just a rhetorics. You're already a winner. This entitled to a prize, and the high level that you showed makes me sure that you're gonna have a very bright performance at these meets.
Thank you all. It just leaves me to say congratulations to all of you again. And one thing I just wanted to state before we go, I understand, I hope Joaquin doesn't mind me saying so, I understand that this was this CIR room, the Chartered Institute of Arbitrators room. If you want any feedback, we're all listed on the Chartered Institute of Arbitrators Brazil branch website, or indeed in the main website. You can find our details there, and do send us emails if you'd like any personal feedback on a one-to-one. We'll be happy to help however we can. That said, good morning and or afternoon to all of you, and all the best at Viz and in your very bright careers, I'm sure.
Thank you so much, and congratulations.